Okay, so the live stream is starting now. The round will be live on YouTube, and it looks like we are all good to start. Okay, so I will turn it over to our presiding judge.
Excellent. Thank you very much. Megan's job is to keep me out of trouble throughout this process. So if she breaks in at any point, it is because she is doing her job. I have a script I'm going to follow, and we have received the go-ahead for the case of Rogers versus Mars. My name is Judge Matthew. So scoring judges, please make sure to make your audio and video muted unless the bailiff tells you otherwise. I'm going to break from script for a second here and ask the scoring judges to identify themselves and say where they're from.
Hello, my name is Isabel Johns. I'm a second-year law student at UT Law, and I was an AMPEC competitor for 2 years.
Hey everyone, my name is Robert Parrish. I'm an attorney in Texas, practice in Austin.
Hey guys, I'm a recent graduate of UF.
Okay. And
Hi, I'm a former competitor and now coach for University of Dayton mock trial.
David Benner, calling in from Buffalo.
so we've got New York, Florida, Ohio, Texas, and Minnesota. Will the attorneys please make their appearances?
Yes, Your Honor. Good afternoon. My name is Brennan Bartley, and I, along with my co-counsel, Ms. Rebecca Nguyen. Today, we are representing the plaintiff in this matter, Ms. Stevie Rogers.
Good afternoon.
Good day. And for the defense?
Good afternoon, Your Honor. My name is Bruno Pais-LeMay, and I, along with my colleague, Mr. Norman Greenwell, will work on behalf of the respondent in today's matter, Ms. Drew Mars.
Good afternoon, Your Honor.
Good afternoon.
Good
Any
afternoon.
pretrial matters?
Yes, Your Honor. 3 pretrial matters from the plaintiff in this case.
Okay.
First, we'd ask that all objection arguments requiring an offer of proof be heard constructively in a sidebar outside of the earshot of the jury.
That's fine.
Second, we'd ask to invoke Midland's Rules of Evidence 603 and 615, which constructively swear in and sequester all witnesses other than the parties or party representatives.
Any
In this
objections?
case,
Right. Any objections to that?
No objections, Your Honor. The defense would just like to recognize that our party opponent or our party representative is Ms. Drew Mars.
Okay. All right.
and our party representative or our party, Stevie Rogers, will be present throughout today's trial.
Any objections to that?
No objections, Your Honor.
Okay. And on behalf of the defendant?
I'm sorry, one more matter, Your Honor.
Okay, so you have 4.
I counted 1 as 2, I suppose. The last matter is we'd ask the court to take notice of the fact that exhibits 1 through 7 have been pre-admitted for the court and jury's convenience. No further foundation is needed for testimony regarding those documents.
Any objection?
No, Your Honor, that's exactly our understanding.
Okay. Anything else? Do you have a 5th thing on behalf of the plaintiffs?
No, Your Honor. With that, the plaintiff is ready to proceed to opening statements.
And for the defense?
A few brief matters, Your Honor. Your Honor, while normally in deference to the court, we'd stand during all examinations and speeches. Given today's unique circumstances, are we? Yes.
No worries. Yep.
Thank you, Your Honor. And lastly, if at any moment we advise the court, if you can't see or hear us, please feel free to interrupt and we'll get that taken care of.
Okay.
With that, Your Honor, the defense is ready.
All right. Opening statements on behalf of the plaintiff.
Yes, Your Honor. One moment, Your Honor, just so I can set up the camera.
Sure. Take as much time as you need.
Thank you, Your Honor. Before I begin, can you hear me all right?
Yes.
May it please the court. She had to do something before she lost everything. August 14, 2018. It's a cool summer's night right here in Midland. In an old lakeside mansion tucked away in the very outskirts of the city, this defendant, Drew Mars, is pacing. Her breaths are heavy, her heart is pounding in her chest, her hands are shaking so badly she nearly spills the bottle of bright purple pills she's holding. But she knows what she needs to do. She has to do something before she loses everything. So she makes her way into the master bedroom. Next to a small bed, there's a nightstand with one thing on it, a pill organizer. The defendant takes 2 pills from that organizer and switches them with 2 bright purple pills she knew would kill her victim. And just like that, a fortune became hers. Because today you'll learn that the owner of that mansion, the person who slept in that bedroom, was none other than the defendant, was none other than Agatha Lee, one of the most celebrated crime fiction authors in the entire world. And the defendant that we just heard about, her caretaker, Drew Mars, who you'll learn is the sole beneficiary to Miss Agatha Lee's will. Now today you'll learn that the very next morning, Agatha Lee was found dead in her bedroom. The chemical in those pills found in her system. And within a week, this defendant inherits that lakeside mansion, all future royalties from Agatha Lee's writing, and nearly $20 million in cash. She had to do something before she lost everything. Now, to understand the defendant's actions, we have to go back to the year before Agatha Lee's death. Miss Lee was 82 years old and relied on the care of her caretaker, Drew Mars. And because of that, Agatha Lee decides to leave everything in her will to Drew Mars. Now, if the story of today's case ended right then and there, there'd be no need for us to come into trial today. But that's not the case. Because today you'll learn in the summer of 2018, Agatha Lee reunited with her only living family, her granddaughter, Stevie Rogers, who you'll get the chance to meet today. Miss Rogers will tell you about the countless hours they spent together and how they reconnected. How on the day before her grandmother's death, Miss Lee even told Stevie Rogers she planned on drafting a new will, one that would leave everything she owned to her granddaughter. There's just one problem. The evidence will show that the defendant heard every word of that conversation. Before Agatha Lee even had a chance to finalize her will, you will learn that Drew Mars knew she had to do something before she lost everything. Miss Rogers will tell you how later that same night, she sees the defendant making her way to her grandmother's bedroom. And the next day, Agatha Lee was found dead. That's why the plaintiff, Stevie Rogers, has brought a suit against this defendant. Here in Midlands, there's a law called the Slayer Statute. And what this statute says is that when someone causes the death of another person, they cannot inherit any part of that person's estate or benefit from their will. Today, it's our job to prove to you that this defendant knowingly or purposely caused the death of Agatha Lee. And to do that, and to meet that burden, we're gonna show you 3 things. what the defendant knew, what she did, and what she left behind. So first, let's talk about the first thing, what she knew. Today, you'll learn the defendant knew that every night, Agatha Lee took exactly 2 bright purple pills of her prescription arthritis medication. But not only did the defendant know what medicine Agatha Lee needed to take, she also knew what medicine would take her life. A drug called chloroandramine, a heartburn medicine that Miss Agatha Lee was deathly allergic to, and looked nearly identical to her arthritis pills. And second, what the defendant did. The defendant switched Agatha Lee's prescription with pills that would kill her. And today, you'll hear about a toxicology report that will prove exactly that. Agatha Lee died from taking 2 chloroandramine pills. And third, what the defendant left behind. Today, you're going to hear about a black bag filled with the same drugs that killed Agatha Lee. And that bag was found in the defendant's bedroom, with the defendant's own fingerprints on it. By the end of today's trial, it'll be clear. The defendant knew she had to do something before she lost everything. That's why, at the end of today's trial, we're going to ask you to honor Agatha Lee's wishes, to make sure the product of her life's work goes back into the hands of her family, not her killer. My co-counsel, Brennan Bartley, will come before you and ask that you find this defendant liable for Agatha Lee's death. Thank you.
On behalf of the defense?
Yes, Your Honor. Can you see and hear me okay?
Yes.
They saw what the plaintiff wanted them to see. Normally, we'd be in a courtroom right now. There'd be a lot of wooden furniture. There'd be 6 of you sitting in chairs, and I'd be right in front of you, standing just a few feet away. But that's not the case today. Today, we're having trial by video conference. And that actually gives me the unique ability to control what you see in a new way. Mr. Greeno, can I get the first exhibit? Members of the jury, this is a picture of the victim in today's case, who you learned was the world-famous mystery author, Agatha Lee. We as the defense agree that she died the night of August 14th, 2018. We agree that it happened at her house when she was by herself in her bedroom. And members of the jury, we agree that someone who knew about her fatal allergy to a drug called chloroandramine switched her medication for the poison pills that killed her. But what we don't agree with is who did it. The evidence will show that before the investigation even began, one person knew the method of murder. One person knew where the damning evidence was. One person guided the investigation into my client at every single step of the way. That person was the plaintiff, Stevie Rogers. It's like how just a moment ago, your screen showed you exactly what I wanted you to see. We're here today because from the beginning of this investigation, they only saw what Stevie Rogers wanted them to see. But today you're going to meet someone. The plaintiff's counsel came before you just a moment ago, and in just a few minutes, they said the word defendant 17 times. Throughout the course of today's trial, you're going to hear them say that word, defendant, over and over again. But behind that word, defendant, is a person. She was Agatha Lee's beloved caretaker of 10 years. And her name is Drew Mars. She's human, just like the rest of us, and today you'll see that she is no killer. Now, I want to make something clear. Today, from the moment this trial began to the moment it ends, the plaintiff carries a burden. They alone hold the responsibility to prove by a preponderance of the evidence that Miss Mars knowingly or intentionally caused the death of her friend, Agatha Lee. The plaintiff won't be able to meet this burden today. As the defense, we don't have a burden. We don't have to call a single witness or show you a single piece of evidence, but we will, to tell you what truly happened. Because you see, members of the jury, what the plaintiff left out in their opening statement is that on July 4th, 2018, Stevie Rogers, the plaintiff, shows up to her grandmother's house after having abandoned her for 10 years. Her $2 million trust fund had run dry. She needed the money. You're going to hear from Miss Mars, my client, today. She's going to be brave enough to take the stand, and she'll tell you that when Stevie showed up, she and her grandmother started talking more. But that over the course of a month, that relationship did build. But that conversation that happened on August 14th, 2018 in the study, well, it actually went a little different. You're also going to hear from Ryan Cabrera. Ryan Cabrera was Miss Agatha Lee's biographer. And she'll corroborate that the conversation in the study was Agatha Lee telling Stevie Rogers no. No, I am not writing you back into my will. No, this is for your own good. The evidence will show that Stevie Rogers knew that chloroandramine was fatal to Agatha Lee. The evidence will show that Stevie Rogers had access to Agatha Lee's room on August 14th, 2018. And members of the jury, the evidence will show that it was specifically the evidence that Stevie Rogers told the detectives to investigate, that she knew where to investigate, that led to this lawsuit against my client, Drew Mars, today. You see, they just told you that Drew Mars had to do something because she had already lost everything. Members of the jury, what you'll see today is that the plaintiff, Stevie Rogers, had to do something because Stevie Rogers had already lost everything. And that's why she made it so that they saw what she wanted them to see. That's why at the end of today's trial, my co-counsel, Mr. Greenwell, will come before you and he'll ask you to hold the correct verdict in this case, to find Miss Drew Mars not liable for a crime she did not commit. Thank you.
All right, thank you. This will be a fun round. Any evidence on behalf of the plaintiff?
Yes, Your Honor. At this time, we'd like to call our first witness to the stand, Ms. Stevie Rogers.
Go ahead.
Good afternoon. Please introduce yourself to the members of the jury.
Good afternoon. My name is Stevie Rogers.
Now, Miss Rogers, where are you from?
It's very complicated. I won't bore you, but basically my dad's Lebanese and my mom's American. So I would say I'm a half-half, but I grew up mostly in Lebanon.
And what do you do for a living?
I'm a writer. I wanted to be a murder mystery writer like my grandma, but I decided to go into journalism, because of my background and where I grew up.
And who is your grandmother?
Agatha Lee.
Now, I want to talk to you about the reason why we're all here today, today's case. Can you tell us how you're involved?
Yes, I filed a lawsuit against Drew Mars. I believe she had something to do with my grandmother's death, and I don't think it's right for her to benefit from it.
Now, by Drew Mars, just to be clear, you're referring to the defendant, Drew Mars, correct?
Yes.
Now, I'd like to talk to you a little bit more about the defendant. Do you know what her relationship to your grandmother was?
Yes, she was her caretaker, like her nurse, basically.
And now I'd like to talk to you about something you mentioned earlier. You said that you thought that Drew was involved with your grandmother's death. Can you explain a little bit more about that?
Yes. Well, it's a little bit complicated. There's a few wills involved.
Whose wills are you referring to?
My grandmother, Agatha Lee.
Would you recognize those wills if they were shown to you today in court?
Yes, absolutely.
Your Honor, at this time, may we display those two wills?
Any objection?
Your Honor, we're actually okay with them being moved into evidence, so we were planning to do so ourselves.
All right. They are admitted.
Now, yes, Your Honor. Now, Miss Rogers, can you tell us what we're looking at right now?
This is one of those wills.
Can you tell us what year this will was created? Or what date is on this will, pardon me?
2008.
Now, what is your understanding of what would happen, or what would you get from this will, if anything?
I would be the sole inheritor of this will. I would get everything.
Now, I'd like to talk to you about the other will. To be specific, the one created in 2018. If that will can be displayed right now. Thank you. Now, Miss Rogers, what's your understanding of what would happen if your grandmother died after this will was created?
Drew would be the sole inheritor. She would receive everything.
Thank you. We don't need the wills displayed anymore. Thank you very much. Now, Miss Rogers, when you knew that the defendant would inherit everything from this will, were you upset at her?
No. Listen, I've had a little bit of a difficult life, and while I was very close with my grandma at one point, after my parents died, I grew distant. I wasn't, talking to my grandma as much as I could have. People deal with grief differently. So I understood why she did what she did. She must have been very disappointed in me.
Were you upset that you would lose the inheritance?
No. Money comes and goes. If I really needed money, I don't like to talk about this, but I could have, I have assets, I could have liquidated them. If I really needed to, I could have, but it wasn't an issue.
Now, Miss Rogers, earlier you mentioned something about being distant from your grandmother. Can you tell us about a little bit more about that?
Sure. After my parents died, I completely tried to ignore my pain. I tried to keep busy. I tried anything I could just to not deal with it. And, I acted out. But in July of 2018, the anniversary of their death, felt like I really needed my grandmother. I needed, her to grab my hand, walk me to the kitchen, sit me on the kitchen counter and tell me everything was gonna be okay. Just like she did when I was a little girl.
So when you visited your grandmother, did your relationship change after that?
Yes. It was like no time had passed, We continued doing our little murder mystery solving and, joking and laughing and spent so much time together. It was amazing, really.
Can you tell us when was the last time you saw your grandmother?
Yes, it was August 14th, 2018, the day she died.
Now, Miss Rogers, on the last day that you saw your grandmother, did you two ever speak about her will?
Yes, we did.
How'd that topic come up?
I was actually asking her if
Objection, Your Honor. This question calls for hearsay. May I be heard?
Yep.
Your Honor, specifically the statements that led to them speaking of the will, those statements would be inadmissible hearsay as they are being offered for the truth that they assert, and they're out-of-court statements.
Any response?
Yes, Your Honor. No specific statements have been elicited, so there's no hearsay.
There are statements coming, though.
Yes, Your Honor. And if I make an offer of proof as to what specific statements Ms. Rogers will be talking about?
Go ahead.
Yes, Your Honor. Ms. Rogers will be talking about how Agatha Lee told her she was planning on, or how Ms. Rogers told her she was planning on switching her will back to her. That falls under the exception to hearsay 80333 as it's a plan, so it's not hearsay, or an exception to hearsay, rather.
May I be heard, Your Honor?
I think you mean an exemption, but yes, go ahead.
Your Honor, we agree that the statements, particularly about the will, would fall under the 8033 exception and have no problem with them. But opposing counsel's specific phrasing of the question was, what conversation led to you talking about the will? And those statements specifically would be hearsay and inadmissible today.
I agree. The objection is sustained.
Yes, Your Honor. Now, Ms. Rogers, can you tell us a little bit about what happened during this conversation with your grandmother?
Sure. She looked into my eyes and she said, "I love you so much and I really want you to follow your dreams. I want to support you. I will leave everything to you and I will set up a meeting with my lawyer later and finalize this." I was so touched, it meant a lot to me.
Now, Ms. Rogers, after your grandmother told you she was going to leave you everything, during this conversation, were the two of you alone?
Kind of. I mean, we were the only people in the room. Yeah.
Ms. Rogers, what do you mean by kind of?
Well, we leave the room and I see Drew with her ear on the wall. She looks like she was listening to the conversation.
When you saw that the defendant was pressing her ear against the wall, how did she react?
I mean, she kind of at first, was shocked that we came out, and then my grandma, she went to get her jacket from the closet, and then Drew, she said she did something weird.
What did she do?
Her eyes got really squinty, her face got red, and she mouthed, she said, "No way."
Now, Ms. Rogers, I'd like to move on and ask you about what the defendant knew before your grandmother's death. Are you aware of the type of work that she would do for your grandmother?
Yes, I mean, she cooked, she cleaned, she fixed grandma's medicine.
Now, that medicine you mentioned, did you ever talk to the defendant about that?
I mean, not really. I didn't know what medicine grandma took, but there was once she mentioned an allergy grandma had to some medication.
When was this conversation you had with the defendant about your grandmother's allergy?
See, like 1 week before Grandma died, early August.
Do you know the name of that medication the defendant was talking about?
Chlorandromine.
Now, Ms. Rogers, I'd like to move on and talk to you about what the defendant did the night your grandmother died. Did you see her that day?
Yes, I saw her that night.
What was she doing that night?
Well, I was going downstairs to grab some tea, and I see her leaving her room, going to Grandma's room, holding something.
Can you tell us what time it was when you saw the defendant heading to your grandmother's bedroom?
Must have been like 9:35, 9:40, sometime like that.
What did you do when you saw this?
Nothing. You know, I wish I thought of something. I wish, you know, I did something, but at the time I didn't think anything of it. You know, she always deals with Grandma's medicine and always, you know, takes care of her. So nothing.
Now, Ms. Rogers, what happened the very next morning?
Drew, she knocked on my door at like 8:30 in the morning, and she said that Grandma wasn't breathing.
When she told you your grandmother wasn't breathing, what did you do?
I went to her room. You checked her pulse. I told Drew, you know, do CPR, do something. I called 911. But there was nothing we could do. She was gone.
Thank you, Ms. Rogers. No further questions at this time, Your Honor.
Ross?
Yes, Your Honor. Now, Ms. Rogers, I'm just going to ask, can you hear and see me okay?
Yes, I can.
You've never had to work a day in your life, have you?
Not a typical job, no, you know, thank God.
In fact, the extent of your job history, in your own words, was that you learned to play some music?
I'm sorry. Yes?
And you started two novels.
Yes.
That's because in 2008, your parents left you a trust fund when they passed, correct?
Yes, they did.
And you inherited $2 million cash.
Yes.
As her last surviving family member, your grandmother, Agatha Lee, also named you the sole heir to her estate in 2008, correct?
Yes, that's right.
That was worth more than $20 million.
I didn't know at the time, but I knew, you know, my grandma was pretty wealthy, so, you know, around that amount.
Now, I want to talk about something. You blew through that $2 million trust fund pretty quickly, correct?
Yes, I invested it almost immediately. Cash, you know, devalues, inflation and all that.
Right, but in June of 2018, that trust fund ran out.
Yes, I had spent the cash on assets, you're right.
Is it your testimony that you spent the cash on assets?
Yes, among other things, I traveled, you know, yeah, pretty much.
That's right, you actually saw the world.
Yes.
Traveled to Europe and Vegas.
Sorry, I'm sorry, what?
Sorry, you traveled to Europe and Vegas.
Yes, me and my mom had planned a trip to Rome, and it was always her dream that we would go. So I went to see it, you know, as a homage to her.
Right, and between 2011 and 2018, you never called your grandmother once.
Maybe once on her birthday, but you're right. I'm ashamed. I never called her at that time. Yes.
You never visited your grandmother once.
You're right, sir. I didn't.
You never wrote her a letter once.
No. You know, I wanted to cut all the ties I had at that time because it was too much. You know, I'm sorry.
Miss Rogers,
If you
your
need a
grandmother.
tissue, we can probably find you one.
I'm sorry. You cut out, sir.
I
Your
said,
Honor.
if you need a tissue, one.
That would be great if there was, Zoom Kleenex.
Miss Rogers, you not once communicated with your grandmother for 7 years.
No, sir, you're right. I didn't.
But she tried to contact you.
Yes, she did. She sent me letters, some voicemail, things like that.
And you finally got one last letter from her, February 2018.
I got a letter from her then, but it wasn't the last letter she had sent me.
Well, in that letter, she told you that you were out of her will.
Yes.
She told you she was giving everything to Drew Mars.
Yes, she said that.
Because Drew Mars had been there for her.
Yes.
And you had it.
Yes.
And you then decided to look for your grandmother just a few months later.
Yes, it was the 10th anniversary of my parents' death.
That was July 4th, correct?
Exactly, sir.
But you actually started looking for your grandma in June of 2018, isn't that correct?
Yes, I was trying to find her address and I couldn't find it. So yes, sir, you're right.
June of 2018 was when your trust fund finally went dry, isn't it?
I still had some cash left, if that's your question.
Well, you had about $12,000 in cash, correct?
Yes.
That was the only money you had in your bank account.
That's the only cash I had, correct.
And when you hired this investigator, he found your grandmother's house in a different state.
Yes, she had moved. That's why I couldn't find her to begin with.
Right, she moved and she didn't tell you.
Yes.
But you showed up on July 4th.
Yes.
So let's talk about what happened when you got there. When you arrived at Lee Manor, there were two other people living there.
Yes, my grandma and Drew.
And Drew was her caretaker of 10 years, correct?
Yes, exactly, sir.
You knew that Miss Mars stood to inherit your grandmother's entire $20 million estate when you arrived.
Yes.
Give me 1 second here. I'm going to lower my computer volume here. So I want to go over some critical information with the jury. Before Miss Lee passed away, you were aware she was deathly allergic to a medication called chloroandramine.
Yes, I think Drew talked about it a week before.
You knew that one pill could kill her.
Yes.
And you knew that it was available over the counter.
Yes, I learned that later.
And on August 14th, you were home alone for parts of the day.
Did you say August 18th, sir? Sorry.
August 14th, you were
14th.
home alone for parts of the day, correct?
To be fair, you have a lot of feedback on your, I don't know if you have another person in the room with the computer on.
No,
but
I think it's just my microphone's getting kind of funky here. Give me 1 second, Your Honor.
let's unfunky it.
Either that or a suggestion was maybe to go ahead and mute while the other person is talking.
And Megan is the expert on this, so I would defer to her. So why don't we try again?
Your Honor, let me try. So point of order here, I'm going to try and change from my mic to the built-in microphone here on the computer.
Okay. Yeah. No, take as much time as you need. And I think our bailiff will be understanding if we bump up against all loss.
Your Honor, can you hear me better now?
So I can hear you fine. The issue was there was an echo.
Miss Rogers, can you hear me okay now?
Yes, I can. I will also try and mute when I'm not speaking so that nothing happens.
All right,
Yes, Miss Rogers.
let's proceed.
Now, Ms. Rogers, I want to walk through your interactions with the official investigator assigned to this case on the morning of August 15th. That was Detective Nura Khan, correct?
Yes.
And she actually wrote a report that you would recognize.
Yes, sir. I saw that later.
Mr. Greenwell, can I get Exhibit 6 on the screen, please?
This is pre-admitted, right?
Yes, Your Honor.
Got it.
Now, according to this report, it seems fair and accurate to you, correct, Ms. Rogers?
Yes. Yes.
Now, according to this report that you're familiar with, Detective Khan arrived at Lee Manor at 9:30 in the morning on August 15th.
Yes, that's what it says.
I want to paint a picture here. You were already standing outside.
Yes,
Drew was inside.
I think so, yes.
When you learned your grandmother passed, you already insisted on calling the police.
Yes, I did.
And you insisted Drew Mars murdered your grandmother.
Yes, I believe that's what happened.
And this report says that there was no signs of foul play.
That's what it says, yes.
When you were in the room where your grandmother passed, you were insisting that photos specifically be taken of the pill organizer, correct?
Yes,
When Agatha Lee's body was removed from the room, you insisted Detective Khan search Miss Mars's bedroom, correct?
yes,
And over the course of that week, you specifically insisted that they do a toxicology screen, correct?
yes. Every single test they could. I insisted on it.
And they did take the photos of that pill organizer.
Yes, they did. They took pictures of many parts of the house. They were very diligent. I really appreciated their efforts.
They did search Miss Mars's bedroom.
Yes, I believe so. I think they asked her to search it that day, but she said no or something, and then they had to come back another day and search it.
And they did perform that tox screen you asked for.
Yes, they did.
Your Honor, I have no further questions. Mr. Greenwell, you can take this report down.
Anything more with this witness?
Yes, Your Honor. Maybe do a redirect. Now, Ms. Rogers, opposing counsel asked you about the time you spent away from your grandmother. Can you tell us why you weren't in contact with her during that length of time?
Yes, like I said, everything about my grandma and her house, it reminded me of my mom, and it was too painful. It was too painful. I'm ashamed. Family means so much to me, and I'm ashamed that I had ignored her for many years. But I was a kid. I was in my 20s, So yes.
And Ms. Rogers, how did you learn about chlorandramine?
Drew told me about it.
Objection, Your Honor. Asked and answered. May I be heard?
Yes.
Your Honor, while we agree that this is within the scope of my cross-examination, we disagree that they're allowed to re-ask this question simply because I brought it up. They asked this question on direct examination, and we learned that it was Drew Mars who told Stevie Rogers about the allergy. To simply put this on the record again would be cumulative.
The objection is overruled. Proceed.
Yes, Your Honor. Actually, with that, we are done with this redirect.
Okay, anything else with this witness?
No, Your Honor.
All right, any further evidence on behalf of the plaintiff?
Yes, Your Honor. At this time, the plaintiff calls Mark Bond to the stand.
Very good, you can proceed.
Good afternoon. Could you please introduce yourself to the members of the jury?
Hey, Sherry, how you doing? My name is Mark Bond.
Where are you from, Mr. Bond?
I grew up about 10 minutes out of downtown Philly. I was born and raised there.
What do you do what brought you to Midlands after being raised in Philadelphia?
Well, coming out of college, I figured I had two choices. I could move out on my own and get a job, or I could move back home with my parents. It was an easy choice for me. My parents, they said no. So I moved out. I started working.
What do you work on?
I'm a private investigator. You see, I take a look at the facts. No biases, no judgment. That's my job. I bring the truth to the people of Midlands.
How long about have you been a private investigator?
I've been doing it for years. I've seen all kinds of things. You might have heard of my last case. It was an investigation into the corruption of the Public Irrigation Commission. I called it I Don't Give a Damn.
Well, sir, I want to talk to you about this case specifically.
Sure.
How'd you come to be involved in this case?
I was hired by Miss Stevie Rogers a few times to look into a few things for her.
What was the first time Miss Rogers hired you?
That was back in June 2018. She calls me up, tells me she needs help finding a missing grandmother. So I found her.
What about the next time?
That was it was August 15th, 2018. She calls me up, tells me her grandmother's gone. At first I'm thinking, dear Lord, how many times can you lose the same woman, but she meant she was dead. I packed up my things. I came down the Midlands as soon as I could.
Well, I want to talk about what happened when you arrived on scene. When exactly did you arrive at Lee Manor?
I showed up about 9:30, right before the cops got there. I goes upstairs. I see Miss Rogers and Miss Myers, and I see Agatha too. She wasn't breathing.
What happened next?
I started searching. I looked around the house, see if I could, dig up some truth.
Well, as part of your searching around the house, did you find anything related to this case?
I did, yeah. I was looking all over the second floor, and I got to Miss Myers' room. So, I goes inside, and that's when I find this email she sent to one of her friends.
Do you think you'd recognize this email if I showed it to you in court today?
Sure.
Your Honor, at this time, permission to display what's been marked for identification purposes only as Exhibit 13, an email.
Any objections?
None at this time, Your Honor.
Okay, go ahead. Well, you published it before.
Yes, Your Honor. Detective Bond, can you tell us what are we looking at here?
Sure. This is the email that I found on Miss Myers' computer that she sent to one of her friends.
Is it a fair and accurate copy of that email?
It looks the same to me.
At this time, Your Honor, we offer Exhibit 13 into evidence.
Any objections?
No objections at this time, Your Honor.
Got it. It's admitted.
Detective, can you tell us what stood out to you in this email?
Well, you can see here, right? At the email at the top, it says it's from Myers to one of her friends that they's talking about Agatha's will. In the email, Myers says she knew she was getting everything. She was going to be getting millions of dollars. This was totally going to change her life.
Did the defendant ever talk to you about what she knew about Agatha Lee's will?
Yeah, but she didn't say that. At the will reading a few days later, she kept saying she didn't know nothing about it. She had no idea. She couldn't believe it.
Detective, I want to talk to you now about the cause of Agatha Lee's death. Are you familiar with the toxicology report and autopsy in this case?
I am, yeah.
Do you know what the cause of Agatha Lee's death was?
Sure. It says she died due to an allergic reaction to chlorandramine. It's this heartburn medication.
Did the defendant ever speak to you about what she knew about Agatha Lee's allergies?
She did. She told me that she knew Lee was allergic to chlorantramine. She told me a couple of pills of those could kill her.
Well, sir, have you ever seen a chlorantramine pill before?
Sure. Yeah, I've taken them a few times myself. These small, round, purple pills. They got no smell, no taste. It's like my mom's casserole.
Do you know if any chlorantramine pills were found at Lee Manor?
Sure. Yeah, I was with the police when they searched the house, and we found a bottle of them. They was in this black bag.
Do you think you'd recognize a photograph of that black bag as you found it when you searched the house?
Yeah, I'm sure I would, yeah.
Your Honor, at this time, permission to display what's been marked for identification purposes only as Exhibit 14, a photograph.
Any objections?
None at this time, Your Honor.
Go ahead.
Detective, can you tell us what we're looking at here?
Sure. Yeah, this is a photograph of that black bag we found. You can see it's right there underneath that blanket. It's sticking out a little bit.
Is this a fair and accurate depiction of that black bag's appearance and location when you found it?
It looks the same to me.
At this time, Your Honor, the plaintiff moves Exhibit 14 into evidence.
Any objections?
None at this time, Your Honor.
Okay, admitted.
Detective, can you tell us inside or on that black bag, was there any forensic evidence found telling you who it belonged to?
We did find a partial print, yeah, while we was investigating. It belonged to Drew Mars. We found the print on the exterior of the bag, on the zipper.
So this black bag with the bottle of chlorantramine pills inside with the defendant's fingerprint on the zipper, where in the house was that found?
We found both the black bag with Mars's print and the bottle of chlorantramine stashed inside of Drew Mars's closet.
Thank you, Detective. Your Honor, nothing further at this time.
Anything else with this witness?
Yes, Your Honor. Permission to cross.
Go ahead.
Good afternoon, Mr. Bond. Can you see and hear me okay?
Yes, sir. How you doing?
I'm doing fantastic, sir.
What do you hear?
Nana was murdered. That's what Stevie Rogers told you, right?
When?
Well, she told you this in a phone call that you had with her.
Right. Yeah. It was that same day. It was August 15th. She calls me up. That's what she told me.
That phone call happened at 8:45 in the morning.
I'll take your word for it. That sounds good.
Now, she didn't say Nana passed away in her sleep, did she?
No.
She didn't say, I think there's something wrong with Nana, did she?
I didn't hear that, no.
She didn't say, I think Nana needs to go to the hospital, did she?
I didn't hear nothing about no hospitals, no sir.
She specifically said Nana was murdered, right?
That's what she told me.
So you decided to go and investigate.
Right. She called me up, so I came down to Lee Manor.
You arrived at Lee Manor at 9:25 in the morning that same day.
That sounds about right, yeah.
And when you got there, you went to go examine the body.
Sure. I went up to the second floor. I saw Miss Mars, Miss Rogers, and I saw Miss Lee too.
To be clear, you arrived on the scene before law enforcement did, right?
Yeah, there was no cops there when I got there.
Now, when you examined the body, you didn't find any blood?
No blood, no.
You didn't find any signs of a struggle?
Nothing from what I saw, no.
No signs that Miss Lee had been strangled?
Strangled, no, sir.
So, to you, it just looked like a woman died in her sleep, right?
I've seen too many to count, so sure.
But that's not what you told us in court today, is it?
What do you mean?
You didn't say that she just died in her sleep. You specifically said that Agatha Lee was murdered, right?
Well, she didn't die in her sleep. The autopsy report said she was murdered.
So I want to talk about your credentials for just a second. You're not a police officer, are you?
No, sir.
You've never had any police training?
No.
You've never had any criminal justice education, have you?
I took criminal justice 5 in college. I got a B, so not really, no.
But you don't have a degree in criminal justice.
No, sir.
Yet you were still paid $10,000 to find Miss Lee back in June of 2018.
That's what I do. I'm a private investigator, sir. I'm pretty good at what I do.
But directing you back to the question, sir, you were paid $10,000 to find Miss Lee.
That's right.
You were paid by Stevie Rogers, right?
That's right, yeah.
To be clear, this is the same Stevie Rogers that's on call with us today.
Yeah, I'm assuming so.
And that's the same Stevie Rogers that's paying you $25,000 for your investigation.
Right, when I showed up, she told me if I could help her out, she'd pay me more.
So let's talk about what $25,000 bought Miss Rogers. You spoke to Miss Mars on the 15th, didn't you?
I did.
You learned that Miss Mars was Miss Lee's caretaker.
Yeah.
You also learned that Miss Lee had a very severe allergy to something called chloroandramine.
That's right. Those was those pills we was talking about earlier.
You asked to search Miss Mars's room, didn't you?
I did, yeah.
But she said no.
Right.
But you did it anyway.
Right, yeah, I was looking around the second floor and I went into her room.
You went to her room without her consent.
Right, I was doing a search.
You opened up her computer.
I did, yeah.
You opened up her email.
Right, that's when I found that email that we was talking about a little bit earlier. The one we was talking about the will and everything.
Now that email, you took a picture of that email, didn't you?
I did, yeah.
And you did all of that without her consent, right?
Yeah, no, I didn't ask her to borrow a laptop, no.
You didn't ask her to take the picture either, did you?
No, I could take it myself. She didn't need to take it.
You never told anybody at the Midland State Police Department about this email, did you?
What do you mean?
When you took the picture, you didn't tell anyone at the Midland State Police Department about it?
Well, I did give it over to him, yeah.
But you didn't tell them about the picture at the time you took it?
Right then and there, no.
You didn't tell Stevie Rogers, the person who hired you, about this picture when you took it, did you?
No, sir, I was in the middle of a search. I was just collecting evidence.
And you certainly never told Miss Mars, the person whose email you searched, about this picture when you took it, did you?
No, sir, like I said.
You didn't tell anybody about this picture for 8 whole days, did you?
It was on that. 8 days sounds about right, yeah.
So that was over a week. You kept this email hidden from anybody, except yourself.
Well, I wasn't hiding it, no.
But you didn't tell anybody, right?
No, I just didn't give it to the cops yet. Yeah, you're right.
So let's talk a little bit about what this all means for the jury.
Let's do
Miss
it.
Mars had access to the pill organizer where the chloroandramine was found, right?
There was no chlorandramine in a pill organizer.
Well, the pill organizer that allegedly had the chloroandramine in it, Miss Mars had access to that pill organizer, didn't she?
I got no idea where the chlorandramine was. We just found the bottle in Miss Mars's closet.
Is it your testimony today that Miss Mars did not have access to the pill organizer where the chloroandramine was found?
Objection, Your Honor. Lack of foundation. May I be heard?
Yes.
Opposing counsel's repeatedly mentioning that it's been alleged that chloroandramine was found in a pill organizer. No such testimony is established. His questions about it right now are lacking foundation. It's confusing the issues for the members of the jury.
Your Honor, may I respond?
Yes, of course.
Your Honor, the witness, Mr. Bond, has access to the toxicology screening that told us that Miss Lee died from chloroandramine poisoning. Mr. Bond also has the testimony that, or has Mr. Bond is also familiar with the investigation report of Detective Nora Khan. She was the lead investigator on for the death of Miss Lee.
Right. So let's clean up the foundation.
Yes, Your Honor.
The objection is sustained.
So, Mr. Bond, you're familiar with the investigative report of Detective Nora Khan, right?
That's right. Yeah, Detective Khan.
She was the lead investigator on the case.
That's right.
Now, you know from that report that there was a pill organizer that was found on Miss Lee's nightstand.
That's right. In Miss Lee's room, she's got this little nightstand there, and there was a weekly organizer sitting right there.
Now, to your knowledge, she only took pills from that organizer.
Objection, Your Honor. Calls for the witness to speculate.
Your Honor, may I respond?
The witness can answer if he knows.
Mr. Bond.
The objection is overruled. Sorry.
Mr.
Because
Bond.
The Midlands Court of Appeals is very stringent. So the objection is overruled. Go ahead.
So, Mr. Bond, to your knowledge, the witness or Miss Lee only took pills from that pill organizer. To your knowledge, right?
I mean, I got no idea. Maybe she got a headache and had some aspirin, during the day, but I know she took pills from there.
So, Miss Mars was able to go into that room to switch out those pills, right? There wasn't any lock on the door?
Lock on the door. I didn't see no lock on the door, no.
So, if that's the case, Miss Rogers also had access to that pill organizer, didn't she?
Right, like you said, no lock on the door, so.
Miss Mars was aware that Miss Lee was allergic to chlorandramine, wasn't she?
Right, that's what Miss Mars told me.
But so was Miss Rogers, right?
Right, yeah.
Miss Mars knew that if Miss Lee were to ingest chlorandramine, she would die, right?
Miss Mars, yes, sir.
But so did Miss Rogers.
Objection, Your Honor. Lacks foundation, speculation.
Your Honor, may I respond?
No, it's sustained.
Miss Rogers knew that Miss Lee was allergic to chlorandramine, right?
Yes, sir.
And Miss Mars told you that earlier in 2008, Miss Lee had suffered a very heart attack, right?
Right, she did tell me that, yeah.
That was from that same chlorandramine.
I think so, yeah.
Thank you for your time, Mr. Bond. Nothing further at this time, Your Honor.
No
Anything
worries.
else with this witness?
Yes, Your Honor. Redirect examination.
Go ahead.
Mr. Bond, opposing counsel was asking you some questions about what exactly was said to you on that phone call on the morning of August 15th. I want to make something clear here. Are you a paramedic?
No, sir, I shouldn't be saving anybody's life.
When you're called by people and retained, do people often tell you to come get their grandmother to a hospital?
No, sir.
Do people ever tell you to help them take people to the hospital?
No, sir.
In your experience when investigating a murder, are you typically retained before or after someone has died?
Usually they don't need me before, sir, so it's always after.
Thank you, sir. Your Honor, nothing further.
Anything else with this witness?
No recross, Your Honor.
Okay. Any further evidence on behalf of the plaintiff?
No, Your Honor. At this time, may Detective Bond be excused and the plaintiff would rest our case in chief.
Okay, that's fine. I will turn it over to Megan, who is our bailiff, for a moment to see if we have time for a break or if we are going to truck through.
We do have time for a break because we do not take one between defense case in chief and closings.
That's why I asked.
So we should be good with our all loss. We should be fine to take a 10-minute break right now.
Okay.
And I will put the teams into breakout rooms and the
Great.
judges will stay here.
Okay, so at 4:20 Central Time, I have no idea where you guys are, but 4:20 Central Time, we'll come back. Sound good?
Sounds great, Your Honor.
Yes, Your Honor.
All right, we'll see you then.
And just a note to the judges, if you guys are still here, we are still streaming, so make sure that you have everything muted and your cameras off, which it looks like everyone's good now.
Yeah, I'm sorry, I had to rejoin. I'm not sure if we was in breakout rooms or as I can get there.
Oh, I was muted. You need to change your name again as well. You are on the plaintiff team, correct?
Yes, ma'am.
Judges, as you come back, if you could please let me know so I know when we can start up again.
I'm here.
Okay. All right. It looks like we have everyone back. So, Judge, we are ready to proceed.
Okay, and your cat in the background is very adorable, by the way.
Thank you.
Any evidence on behalf of the defense?
Yes, Your Honor. The defense calls Miss Drew Mars to the stand.
Okay, let's proceed.
Please introduce yourself.
Hi, my name is Drew Mars.
Miss Mars, can you hear and see me okay?
Yes, I can.
Now, we've heard a lot about you from others today. Would you tell us a little bit about yourself in your own words?
Sure. I was born in Cuba. My family moved to this country when I was just 5 years old. I was raised in Alabama, but moved right after I got my bachelor's in nursing.
So where do you live now?
Right here in Midlands, at Agatha Lee's house. She's who I lived with before she passed.
Miss Lee, I want to show you a picture. Mr. Greenwell, could I please get Exhibit 1 up on the screen?
And this is pre-admitted, right?
Yes, Your Honor.
Got it.
That's correct.
Pursuant to stipulation 16. Miss Mars, who was this to you?
That's Agatha Lee. Technically, she was my boss, my patient, but she was so much more than that to me. I worked for her for about 10 years. She was a friend, a grandmother, a role model. She was family.
And what role did you have under her employ?
I was mainly responsible for her medication. I organized her pill organizer every Saturday, but really I did whatever she needed me to do.
So what were some of your other responsibilities?
Housekeeping, cooking, driving, you name it.
Now, you mentioned that you and her were close. How would you spend your free time?
We talked a lot, watched movies, played games together, read together. We just enjoyed each other's company.
Let's talk about the person who's suing you today, the plaintiff, Stevie Rogers. Now, how do you know her?
Well, she was Agatha's grandchild. I don't really know her on a personal level. For the 10 years I was working there, Stevie didn't come around very often. As far as I know, she really hadn't even called Agatha since at least 2009 and never really wrote any emails or letters.
Objection, Your Honor. Lack of foundation as to the latter portion of the witness's answer.
Okay, explain the.
Excuse me, Your Honor, I'm sorry.
No, explain the objection.
Yes, Your Honor. There's a lack of foundation as to the statements that Stevie Rogers didn't send any emails or text messages to Miss Lee.
Okay.
May I be heard, Your Honor?
Of course.
Your Honor, this testimony has had sufficient foundation laid because we established that Miss Mars lived in Miss Agatha Lee's house, was with her all the time, and had several responsibilities, and thus spent a lot of time. Furthermore, the witness phrased their answer saying, "to my personal knowledge," which means we've laid sufficient foundation for this to be admissible testimony.
May I be heard, Your Honor?
Of course.
Unless the witness's duties consisted of reading Agatha Lee's emails and text messages, as well as the ones that she received, there's not sufficient foundation to say whether or not Stevie Rogers sent any of those.
Okay, the foundation objection will be overruled. Do you have a different objection?
Not at this time, Your Honor.
Okay, then overruled.
Ms. Mars, do you know if Miss Lee tried to talk to the plaintiff?
Yes, I saw her trying to reach out to Stevie all the time. She wrote her letters, left her voicemails. It was horrible watching her go through that. My heart broke for her every time she sent out a new letter. And finally, she decided she would send one last time.
What did she say?
Objection, Your Honor. Lacks foundation, speculation. May I be heard?
Of course.
There's a lack of foundation, and it's speculative for her to say that Agatha Lee decided she would send one last time. We don't know how this witness knows that Agatha Lee decided this would be the last letter she sent, or even if this was the last letter she sent.
May I be heard, Your Honor?
Of course.
Your Honor, we're okay with specifically striking the witness's portion of the answer where she said one last time, but we do believe that it is within the witness's purview to say that she did send a letter in February 2018, and that these statements can be conditionally let in so that we can lay that foundation in the next question.
Anything else?
Your Honor, our objection is specifically to the one last time.
Okay, which, from what I understand, is okay to be stricken.
Yes, Your Honor, we're okay striking one last time.
Okay, so ordered. And do you have any other objections?
No, Your Honor.
Okay, all right. Then we'll proceed.
Ms. Mars, did Ms. Lee show you this letter?
She did. It was a letter where she told Stevie that she was tired of supporting her, that she was going to write her out of the will, that she was going to leave everything to me.
Objection, Your Honor, hearsay as to she was tired of supporting her.
There you go. Okay, response.
Yes, Your Honor. This falls under the hearsay exception 8033, a then existing mental, physical, or emotional condition.
Okay, explain the exception.
Yes, Your Honor. These particular statements talk about the witness's mindset, that being how she felt about her granddaughter, Stevie Rogers, at the time she wrote the letter.
Response?
Yes, Your Honor. Then existing mental, physical, emotional condition, those are statements like happiness, sadness, or her intent. Saying what she is tired of, though, that doesn't fall under that exception and isn't admissible.
May I be heard, Your Honor?
No, the objection's sustained.
Yes, Your Honor.
Strike that portion of the answer, Your Honor.
That portion is stricken. The jury can disregard.
Ms. Mars, you said in your previous answer that Ms. Lee wrote Stevie Rogers out of the will. Did she say anything else?
Well, she said that she would be leaving everything to me.
And you then had a will written under your name, but Ms. Lee had a will written under your name that same month, correct?
That's right.
Now, when did you find out about this new will?
In February of 2018.
And we've heard some testimony today that at the will reading in August, you acted surprised when the contents were read. Could you talk about why that happened?
I was scared that they would think the worst. Stevie cried murder the second Agatha passed, and I was worried they'd only see what she wanted them to see.
Objection, Your Honor. Non-responsive, lack of foundation. May I be heard?
Yes.
Your Honor, the witness's answer regarding Stevie crying murder as soon as Agatha passed, there's a lack of foundation, frankly, that is true, but it's also non-responsive to the question at hand about why she did or did not state that she was aware of this will. She can testify that she was frightened of disclosing that information, but these statements about what Ms. Rogers was doing are non-responsive.
May I be heard, Your Honor?
Of course.
Your Honor, this witness is speaking about her own reasons why she acted in a certain way. I particularly phrased the question to ask why she pretended like she didn't know the contents, and the witness responded giving the reasons why. There's no inadmissible testimony in this question.
I agree. The objection is overruled. Proceed.
Now, Ms. Mars, we've also heard that in the hours leading up to Ms. Lee's passing, she and the plaintiff had a conversation in her study. Do you remember that conversation?
Yes, I do. I remember I made Agatha some tea, and I was walking it up to her study when I came up to the door and I heard them speaking.
What did you hear?
Oh, I heard Stevie talk about how she had proven her loyalty and how she wanted to be put back in the will.
Go ahead.
Agatha said that she loved her, but for Stevie's own good, that she wasn't going to put her back in the will.
What happened after you overheard Miss Lee say she wasn't going to put Miss Rogers back in the will?
I drove Agatha to lunch with a friend. I ran some errands, and I picked her back up from lunch.
Did the plaintiff, Miss Rogers, join you?
No, when we left, she was still home.
So when you left, was there anyone else in the house besides Miss Rogers, to your knowledge?
Not to my knowledge. The only people who lived there were me, Agatha, and Stevie.
Now, while you were out of the house, would someone have been able to access Miss Lee's pill organizer?
Well, it was just on top of her nightstand in its usual place. I'm sure it wasn't kept under lock and key or anything like that. So sure, somebody could have accessed it.
Now, what happened after you picked up Miss Lee on the afternoon of July 14th?
We just went home. I remember I made dinner for Agatha and Stevie, and then I went to bed around 9:30 p.m.
And just to be clear, that was August 15th, not July, correct?
That's right.
What did you do?
Well, I went to bed. The next morning, when I went to take Agatha her coffee, she wouldn't wake up.
Did you do anything when you saw that she wouldn't wake up?
Of course, my nurse training kicked in. I checked for a pulse. I checked to see if she was breathing. I yelled for Stevie to call 911. I tried CPR. I thought maybe that could work, but she still wouldn't wake up. So I ran to Stevie's room and she called 911. Next thing I know, Stevie's accusing me of murder.
Ms. Mars, we've heard some testimony today that a bag containing chloroandramine was found in your closet. Did it belong to you?
No, I've never purchased chloroandramine. The bag wasn't mine. Look, I know how it looks, and I wish I could tell you how the bag ended up in my closet.
Objection, Your Honor. At this point, non-responsive.
Okay, explain.
Yes, Your Honor. The witness's answer about the bag not being hers, about not purchasing chloroandramine, that's all responsive to the question. Her talking about her desires to be able to explain that isn't responsive and isn't admissible.
May I be heard, Your Honor?
Of course.
Your Honor, my client has a right to maintain her innocence. This testimony came out in court today that bag was found in her closet. If that bag doesn't belong to her and she doesn't know how it was there, she's allowed to delve into that.
I guess I agree. This is kind of a strange objection, and therefore overruled.
Now, Ms. Mars, I hate that I'm forced to ask you this. Did you kill Agatha Lee?
No, I've been sitting here listening as if they would suggest that I would poison Agatha. That's so far from the truth. I love her. I would never do anything to hurt her. I was her nurse, her caretaker, and her family. As much as I don't want to believe it's true, Stevie took her away from me.
Objection, Your Honor. Lacks foundation, speculation. Motion to strike the latter portion of the answer.
Go ahead and explain the objection.
Yes, Your Honor. The witness stated that Stevie took her from me. There is a lack of foundation as to how she is able to testify that Stevie Rogers committed murder in this case. She is speculating.
Well, she didn't say murder, but okay. And the other basis?
Your Honor, as part of that, her saying that is speculative, and there is a lack of foundation for her to make that conclusion.
Response?
Yes, Your Honor, it's within the witness's purview, given the evidence we've heard today and the knowledge that she's had already established in trial, that she would be able to make this sentence. Again, my client has a right to maintain her innocence.
Anything
May I
further?
be heard, Your Honor?
Of course.
While his client does have a right to maintain her innocence, she does not have a right to speculate about the actions other people might have taken. The only way she's allowed to testify is if she can testify to something that was within her rationally based perceptions.
Final response, Your Honor.
No, I understand the arguments of the parties. So the jurors of the state of Midlands are the best
It goes to wait,
in the
yes, Your Honor.
United States. And so I'm going to rule that the objection's overruled, and that this goes to the weight of the testimony, not its admissibility. And so the jury can infer whatever it wants from the testimony that it's heard. So the objection's overruled, and I will trust the jurors of the state of Midlands will do their job.
Yes, Your Honor. With that, and given the time constraints, I have no further questions.
All right. Anything else for this witness?
Yes, Your Honor, a cross-examination.
Go ahead.
Ms. Mars, I want to talk about how you lied to avoid suspicion in this case. You were present at the reading of the will on August.
Objection, Your Honor. Argumentative. May I be heard?
Yeah, it's touchy, but overruled.
Yes, Your Honor.
It's cross. Go ahead. Overruled.
Ma'am, I want to talk to you about how you lied to avoid suspicion in this case. In late August, you were present at the reading of Agatha Lee's will.
I was there, yes.
You had actually been shown Agatha Lee's will in February of 2018.
Yes.
You had been told by Miss Lee that you were the sole beneficiary of that will.
That's right. She told me she was disinheriting Stevie and that she would leave everything to me.
She showed you a will proving that she was leaving everything to you, right?
Yes.
At that will reading, it was announced that everything was being left to you, wasn't it?
That's true.
At this will reading, you said repeatedly that you didn't know.
All I said was, I can't believe it. Like I said on direct, I didn't trust Stevie. I didn't trust the private investigator that she hired. They were crying murder from the moment she died. I was afraid that it would look like I had done something suspicious.
Your Honor, motion to strike as non-responsive, the witness's answer. My question clearly called for a yes or a no.
9.
Ms. Mars, I want to break that down. At the reading of the will, you said that you didn't know. Yes or no?
Yes, I said that.
At the reading of the will, you repeatedly said that you could not believe it. Yes or no?
Yes.
The reason that you repeatedly said these things was because you did not want the police to think that you had murdered Agatha Lee. Yes or no?
Objection,
Yes,
Your Honor. Relevance and asked and answered. May I be heard?
Yep.
Your Honor, opposing counsel has already asked this question from the witness, and while she did give context to the answer, she did properly answer the question with a yes or no.
That part's going to be overruled, so go to the relevance part.
Yes, Your Honor. Specifically, that opposing counsel is talking about the witness's motive to lie to the police, and that, Your Honor, her reasons for doing so have already been established, and he's now trying to paint it as though the witness would lie because she did it. This is opposing counsel's inference, and it doesn't actually make any fact in the case more or less likely.
Okay. Any response?
No, Your Honor, I stand for ruling. It's relevant.
The objection's overruled, so go ahead.
Yes, Your Honor.
Ms. Mars, the reason you said these things is because you were afraid the police would investigate you for murdering Agatha Lee. Yes or no?
Yes, I was afraid they'd only see what Stevie wanted them to see.
Ma'am, was that a yes or a no to the question I was asking?
Objection, Your Honor. Asked and answered. The witness did say a yes or no.
Overruled.
Ma'am, yes or no? Was the reason you told these lies to the police that you did not want them to investigate you for Agatha Lee's death?
Yes.
Then I want to talk to you about how Agatha Lee died. As your caretaker, you were made aware of Miss Agatha Lee's health conditions, right?
Of course, I was her nurse.
The reason you actually needed to become caretaker is because she'd had a near fatal heart attack in 2008, right?
That's right.
That near fatal heart attack in 2008, you understood it to have been caused by a single chloroandramine pill, right?
Yes.
And you know what chloroandramine pills are, don't you?
Yes, an over-the-counter heartburn medication.
That's right. As you said, they're sold over the counter, aren't they?
Yeah.
Now, in 2018, Agatha Lee was taking a medication called Winterin, right?
That's right. It's her arthritis medication.
And this arthritis medication, it was your responsibility to set out 2 of those pills per day in her organizer once a week, right?
That's right, along with aspirin and vitamin B.
Now, these Winterin pills, they're small purple pills, aren't they?
That's right.
They both come in a 250 milligram dosage.
Yes.
Chloroandramine pills are small purple pills, aren't they?
Yes, they look the same.
They both come in a 250 milligram dosage, don't they?
Yeah, I believe so.
You said a moment ago that they look the same as chloroandramine pills. Or excuse me, that they look the same as Winterin pills. But I want to be clear here. Chloroandramine and Winterin look indistinguishable to the naked eye, don't they?
That's right.
Then with that in mind, I want to lay out the timeline of the 24 hours before Agatha Lee died. You're aware that the reason Agatha Lee died was from a fatal reaction to chloroandramine in her system, right?
Yes, that's what the autopsy said.
And that she died sometime during the night of August 14th or early morning of August 15th, right?
I think so, yeah.
Now, ma'am, on August 14th, as you said on direct examination, you were here in court today for the testimony of Miss Rogers, right?
I was.
You heard Miss Rogers say that she had a conversation with her grandmother in the study.
Yes, they did speak.
You heard her say that Agatha Lee had told her that she was making her the beneficiary of the will once again, right?
Objection, Your Honor. Needlessly cumulative under Rule 403. May I be heard?
Of course, yes. Go ahead.
Your Honor, opposing counsel has now phrased 4 different questions saying you were here in court when Stevie Rogers said X. They're attempting to simply pad the record with the testimony of their party representative today, and thus it's needlessly cumulative.
Yeah, right. But X is a variable, right? And so the variable changes with every question, and therefore the objection is overruled.
Yes, Your Honor.
Now, ma'am, you were in court today when Stevie Rogers said that her grandmother, in that conversation in the study on August 14th, had promised her that she'd be the heir in the will. Yes or no?
Yes, that's what she said, but it's not what happened.
But you can confirm that what happened is they did actually have a conversation in the study on August 14th.
Yes.
Immediately after that conversation, you drove Agatha Lee to a lunch, right?
That's right.
And while you were driving her to this lunch, she made a phone call, didn't she?
I think so, yeah.
She made a phone call to someone named Kirby, right?
Objection, Your Honor. Learned through hearsay. May I be heard?
Yeah, let me back up and have you repeat that last question.
Yes, Your Honor. This phone call she made to someone named Kirby, right?
Okay, and explain the objection.
Yes, Your Honor. Specifically as to who that Miss Agatha Lee was having this conversation with, that information is learned through hearsay as they are trying to offer for the truth of the matter asserted that the conversation that Agatha Lee was having was with Kirby.
Okay, response?
Your Honor, we're not offering this to prove the truth of the matter. We're offering this to show, one, her subsequent action, and two, as foundational corroborating evidence for further testimony. If I may make an offer of proof.
I really want to hear your argument on the second point, so go ahead.
Yes, Your Honor. As an offer of proof, this witness is going to go on to testify that Agatha Lee's personal attorney is named Kirby Doolittle and that she was aware of that fact. This conversation, whether or not it actually is Kirby Doolittle, we're not sure. But for
why is that admissible under the hearsay rule?
It's admissible because we're offering it to show the subsequent action of this witness. It's our contention that as a result of hearing Agatha Lee call someone who she understood may have been her attorney, she took actions to end Agatha Lee's life because she believed that the will was being changed.
Response?
Yes, Your Honor. It's defense's contention that they can't lay that foundation and that there are no subsequent acts that they're actually going to go into. Furthermore, Your Honor, we do believe that they're trying to assert it for the truth of the matter to later tie in the fact that Kirby Doolittle was an attorney at the will reading.
Oh, anything further?
Your Honor, we're not using it to tie in the fact that Kirby Doolittle was the attorney at the will reading. We're going to ask this witness about her knowledge about who Kirby Doolittle might be.
Okay, so there's a cart and a horse problem. If you're offering it to prove the subsequent course of conduct of the witness, let's do that first. And then you go backwards and establish that the hearsay proved that purpose. So the objection is sustained, but you can lay additional foundation.
Move to strike the relevant testimony, Your Honor.
So ordered.
To clarify, Your Honor, are you looking for foundation as the witness's subsequent action or knowledge of who Kirby Doolittle is?
I just want you to ask questions that will produce admissible evidence. It's not my job to tell you what questions to ask.
Yes, Your Honor. Ms. Mars, after you heard this conversation that Agatha Lee had on the phone, you dropped her off at her lunch date, right?
I did.
It was after you dropped her off at this lunch date that you then went to a pharmacy, right?
That's right. I thought I could kill some time and get some toiletries while I waited for her to be done at lunch.
Now, you've had a chance to view the autopsy, or not the autopsy report, but the police report in this case, right?
I saw it, yes.
So you're aware that that pharmacy you went to sells chloroandramine?
Yeah, I think all pharmacies sell it.
Ma'am, while you were at that pharmacy, you can't tell us what exactly you purchased.
I'm sorry, it was over 2 years ago. I don't remember.
You can't tell it, or at that pharmacy, you didn't pay with a credit card, did you?
No, I think I paid in cash.
You didn't keep your receipt from that trip to that pharmacy showing what you purchased.
Objection, Your Honor. Burden shifting. May I be heard?
Okay, go ahead.
Your Honor, as the court knows, it's the plaintiff and the plaintiff's responsibility alone to provide evidence for the claims that they're bringing forth in this lawsuit. Asking this witness to as to why she didn't keep a receipt, why she paid in cash, is shifting the burden onto the defense to say that we had to provide evidence of her innocence.
Response?
May I be heard? Yes, Your Honor. Under the Midlands Rules of Evidence, we're allowed to comment and ask questions about if they do choose to offer a theory of the case, if they do choose to offer evidence. We're allowed to comment on their failure to provide supporting documentation. It's their contention she did not purchase chloroandramine. We're commenting on their inability to provide documentation that she did not, in fact, purchase chloroandramine. It's not burden shifting.
So you brought it up. What rule says that?
Yes, Your Honor. Just a moment as I review the relevant case law. I'm sorry, if you said something, I didn't quite hear you.
No, I said, of course, take your time. And for the other side, what rule says we can't burden shift? I know there's a constitutional argument about that, but there's no constitution in Midlands.
Yes, Your Honor. A moment to confer the rules real quick.
Yep, of course. Yeah, you can both look. And right now, I'm really glad there's no Midlands Court of Appeals. So.
So, Your Honor?
Yeah, go ahead.
If I may be heard, it would appear, based on my review of the Midlands Rules of Evidence and relevant case law, there is no rule preventing burden shifting and no rule specifically allowing the comment on the inability of the defense to provide supporting documentation.
May I be heard, Your Honor?
Yes, you, of course. Yeah,
Your Honor, there actually is a rule. It's Rule 301, Presumptions in Civil Actions Generally. And that rule states that the party against whom a presumption is directed has the burden of producing evidence to rebut the presumption. But this rule does not shift the burden of persuasion, which remains on the party who had it originally. The defense's understanding of that rule is that given that this is a point that opposing counsel is bringing into question, that we don't have the burden to produce evidence to rebut it.
Okay, you're going to have to give me 1 second to rule on this one.
Yes, Your Honor.
Okay. And while I'm looking, I've been waiting for people to make this objection for years.
One more thing, Your Honor.
Go ahead. Yeah.
The fact in contention that opposing counsel is mentioning is that our claim is that she did not buy chloroandramine. That fact has not actually been elicited in trial whatsoever. What the witness specifically said was that she doesn't remember what she bought. And certainly the burden can't shift on us to then provide evidence of something that she doesn't remember.
May I be heard, Your Honor?
No, the objection is sustained. I again, don't necessarily agree with the rule, but the rule is what it is. So.
Motion to strike, Your Honor.
Granted.
So, Ms. Mars, after you went to that pharmacy, you and Agatha Lee went home, right?
Yes, that's right.
In the entire time you were living with the plaintiff, living with Ms. Rogers, you never once saw her carrying chloroandramine pills, did you?
I don't know. I don't think she ever had them. I don't know.
It's a simple yes or no. Do you remember if you ever saw the plaintiff carrying chloroandramine pills? Yes or no?
No, I never saw her holding chloroandramine.
But just less than 24 hours after your trip to that pharmacy, Agatha Lee was dead of an overdose of chloroandramine. Yes or no?
That's right. She died the next morning.
And you're aware that a bottle of chloroandramine pills was found in your bedroom. Yes or no?
Someone put it in my closet. Yes.
Ma'am, was that a yes or a no to my question? In your bedroom, there was a bottle of chloroandramine pills found.
Yes, the police found a bottle in my closet.
Thank you, Ms. Mars. Your Honor, nothing further.
With that, Your Honor, we ask that the witness be excused.
Okay. Any further evidence?
Your Honor, at this point in time, I'm sorry to interrupt, but I would like to make an announcement that the all loss has been extended from 6:22 to 6:25 due to technical issues that we had earlier. But just a reminder of everyone to keep an eye on the time, please.
That's Eastern time, right?
Correct.
Okay.
Your Honor, at this time, the defense calls Mr. Ryan Cabrera to the stand. May I proceed? Good evening, Ms. Cabrera. Can you hear me okay? Ms. Cabrera, I think you're muted.
It seems you cannot hear me okay. Yes, I can hear you.
Please introduce yourself to the court, spelling your last name for the record.
Hello, my name is Ryan Cabrera. That's Cabrera.
Ms. Cabrera, what do you do for a living?
I'm an author. I used to write poetry and short stories, but I've definitely found a lot more success in writing biographies after my biography on Dylan Hendricks after her attempted murder trial went essentially viral, but in book terms. Ever since then, I've been trying to write stories that write the stories of the celebrities that the people in Midlands care about.
Miss Cabrera, do you know someone by the name of Agatha Lee?
I do, yes. She was one of the best mystery writers of our generation, and you probably know her by her most famous and only work, Death in a Bottle.
How do you know Miss Lee?
Well, by some stroke of luck, she agreed to let me write her biography. So in doing so, I met with her a couple times a week to get content.
Miss Cabrera, I want to talk about some of those meetings that you had. What did you talk about generally during these meetings?
Well, the main reason that I wanted to write this biography was because so much of Agatha's life was private. Because of that, I really wanted to focus our conversations on her childhood, her daughter, how she carried her personal life, her relationship with Drew Mars, all of it. I just wanted to know everything.
Who is Drew Mars?
She was Agatha's caretaker, chauffeur, chef, pretty much whatever Agatha needed her to be.
You mentioned you learned about Miss Lee's relationship with Agatha Lee. Miss Lee's relationship with Drew Mars, my apologies. To you, what was their relationship like?
From what I could see, they were extremely close. Like I said, Drew essentially did everything for Agatha. They lived together for something like over a decade, and from what I could see, again, they were just almost inseparable. Agatha even told me that she was planning on leaving everything that she owned to Drew after she died, and if that isn't close, I don't know what is.
Now let's move forward a little bit to June 15th of 2018. Did you have a meeting with Miss Lee that day?
I did, yes. We met in her study like we usually did.
No. What'd you all talk about during this meeting?
Well, for the first time, Agatha opened up to me about her granddaughter, Stevie Rogers.
How did this conversation go?
Well, I mean, as far as my biography went, it was fine, but it was also kind of a sad story. She told me about how when Stevie was younger, they were very close, but when Agatha's daughter, Stevie's mom, passed
Objection,
away.
Your Honor. Hearsay.
Your Honor, may I respond?
Yes, of course.
Your Honor, this is an exemption to hearsay under Rule 8033, as this goes towards the terms of the declarant's will.
Response?
Yes, Your Honor. This witness just testified that Agatha Lee was talking about the childhood talking about her childhood or Stevie Rogers' childhood. This doesn't go to the declarant's will. This is hearsay.
Your Honor, if I may respond.
Of course.
Your Honor, if I may make an offer of proof.
Yes.
The remainder of this statement was that after Miss Lee's daughter and Stevie's mom passed away, their relationship began to distance. And she'll even go as far to say as Miss Lee said that Miss Rogers abandoned her. This is foundational evidence to suggest why she would disinherit Miss Rogers to begin with, which goes directly towards the term of the will.
Is your response?
One more time, Your Honor.
Pardon me, Your Honor. We're referring to me or?
No, we're good. Go ahead.
Oh, just to be clear, are you talking to me? I'm so sorry, Your Honor. To me, right?
Are you Rebecca?
Yes, I am, Your Honor.
What's your response?
Yes, Your Honor. Opposing counsel has still yet to address the hearsay objection. Just because he is using this to lay foundation for something else does not mean it is not hearsay. It's still hearsay, Your Honor.
I agree. The objection is sustained.
Your Honor, if I may.
You can lay foundation, but...
Well, Your Honor, this is an exception to hearsay under Rule 8033. Though it's still considered hearsay, you can still use it for other purposes. It doesn't make it non-hearsay, Your Honor. It's just an exception.
Okay. And I guess the objection is sustained. If you want to lay foundation for a different argument, you can do that.
Yes, Your Honor. Move to strike.
Granted.
Yes, Your Honor.
Ms. Cabrera, let's move forward a little bit to August 14th of 2018. What were you doing that day?
I had another meeting with Agatha for my biography, of course. We met at a nearby restaurant rather than in her study.
What happened during this meeting?
Well, I noticed that Agatha was a lot less talkative than she usually was, so I asked her what was wrong. She started to tell me about a conversation with Stevie that she had that morning that had been troubling
Objection,
her.
Your Honor. Hearsay again.
Your Honor, if I may.
Of course.
Your Honor, if I may make an offer of proof.
Of course.
The statement that she was going to elicit was that she had to tell that Stevie Rogers had asked her for something that morning, that she had to say no, and that she was hoping that Stevie could forgive her. If I may, Your Honor, this conversation relates to the conversation that was had in the study, and therefore the matter was whether or not she would inherit or disinherit Stevie Rogers from her will. Therefore, this goes directly towards the term of the will and is an exception to hearsay under Rule 8033.
Response.
Yes, Your Honor. We're not referring to any of the statements that opposing counsel just proffered. We're talking about what this witness just said. And Ms. Cabrera just testified that Agatha Lee told her she had a conversation with Stevie Rogers earlier that day. That is a hearsay statement. It's a statement, an out-of-court statement being used for the truth of the matter asserted, and it's hearsay, Your Honor.
Okay, so
Your Honor, if I may?
Yeah, of course. And practically what then existing mental, emotional, or physical condition does it involve?
Your Honor, Ms. Cabrera's statements can't be considered hearsay because she's on the stand testifying. She didn't make a statement during that meeting. She's just talking about what Ms. Lee said to her. Therefore, her statements aren't out of court and can't be considered hearsay under Rule 801. Furthermore, Your Honor, Ms.
Okay, but go ahead.
Regarding the 8033 exception, Your Honor, those statements go towards Ms. Lee's plan to either inherit or disinherit Ms. Lee or Ms. Rogers from her will. Therefore, it's directly under the purview of Rule 8033.
Okay, I'm literally looking at 8033. I don't see plan.
Your Honor, if I may.
Go ahead. Yeah.
Your Honor, looking at Rule 8033 specifically, on page 11 of page 10 of the Midlands Rules of Evidence.
I'm looking at it right now.
It reads a statement of the declarant's then existing state of mind, such as motive, intent, or plan.
Got it.
Therefore, this goes directly to it.
Response.
Yes, Your Honor. This plan that opposing counsel is referring to has no bearing on this specific hearsay statement. The statement was, I met up with Stevie Rogers or had a conversation with Stevie Rogers earlier that day. That is just relaying what happened in the past. It is not a plan. This is still hearsay.
Your Honor, if I may.
Here's what I'm going to do. The juries in Midlands are very good, and I'm going to defer this to the jury, overrule the objection, but the arguments are well stated.
Yes, Your Honor.
The objection is overruled. Proceed.
Ms. Cabrera, you just mentioned a conversation that you had with Ms. Lee on the 14th. What did that conversation entail?
Well, she didn't give me a lot of details, like I said, but she told me that Stevie had asked her for something and that she had to say no to her. She told me that she hoped that Stevie could forgive her.
Thank you for your time, Ms. Cabrera. Nothing further at this time, Your Honor.
Anything else with this witness?
Yes, Your Honor. Cross-examination.
Go ahead.
Before I begin, may I inquire as to how close we are to all lost time, just to make sure?
Very close. We have 22 minutes.
Yes, Your Honor. Yes. Okay, I'll keep that in mind. May I begin, Your Honor?
Yes.
Good evening, Ms. Cabrera. I'm assuming it's evening where you're from right now.
It is.
Now I'd like to talk to you about the meeting you had with Agatha Lee the day before her passing. You remember asking Miss Lee to meet up later that week?
I did, yes.
But she told you no.
Yes.
She told you no because she said she was planning on meeting with her attorney later that week, correct?
That's what she said, yes. So I offered that we reschedule.
And just to be clear, you have no idea why she was planning on meeting with her attorney?
No, we didn't talk about things like that.
So you don't know if she was planning on making changes to her will?
Not a clue.
And you don't know if she was planning on changing her will back to her granddaughter, Stevie Rogers?
I'm not sure, though I will say that her and Stevie weren't very close.
Mr. Bear, I didn't ask you about her relationship with Stevie Rogers. I just asked you whether or not you know she was planning on changing her will back to Stevie Rogers. Yes or no?
Not a clue, no.
Now, Ms. Cabrera, I'd like to move on and talk to you about why you're here today. You'd agree with me that you have a lot to gain from the outcome of this trial?
Not really.
But Ms. Cabrera, isn't it true that before you came here today, you made a deal with this defendant?
I made no formal deal, no.
Ms. Cabrera, isn't it true that before you came here today, the defendant asked you to testify?
She did. She called me and asked me if I could testify, yes.
And you agreed?
Yes, I did.
And after you agreed, she then offered you to take your pick from anything you wanted from Agatha Lee's estate, yes or no?
Well, she asked me if there was anything that I wanted to look over for my book, and I did tell her that I wanted to look over Agatha's book collection, yes.
Ms. Cabrera, are you saying that she asked you to take a look at the things for your book?
She asked me if there was anything I would want.
So after she asked you what you wanted from Miss Lee's estate, like you mentioned before, you said you specifically wanted her private book collection, right?
I did, yes.
And you're aware that some of the books in that private book collection included Agatha Lee's unpublished works?
Of course, I wanted to learn about what else she wrote besides For Death in a Bottle.
But besides that, Ms. Cabrera, isn't it true that you know that these unpublished books could be worth a lot of money?
I'm sure they would be.
Because you'd agree with me that Agatha Lee is a very famous author?
She is, yes.
Her first book sold over 65 million copies?
Something like that, yes.
So you know that these books can make you a lot of money.
I don't know about me personally. I'm not planning on publishing her books for her. If she didn't publish them, that's probably not what she wanted.
But Ms. Cabrera, you'd agree with me that these are worth enough to you to try to hide them from the defendant?
I wasn't trying to hide anything. I asked Drew for the books.
But Ms. Cabrera, you never told the defendant that unpublished books were included in his collection, yes or no?
No, I didn't. I didn't think she would care.
So that was the yes to my question. You never told the defendant that there were unpublished books by Agatha Lee in that collection.
No, I didn't.
Now I'd like to move on and talk to you about something else. So you agreed to testify here voluntarily today, correct?
I did, yes.
And you're aware that you can only get those books if Drew Mars wins this trial, correct?
Yeah, I'm aware.
And you're not worried that Miss Mars will change her mind about this, about giving you those books, are you?
No, not really.
Because in your own words, you're not worried because you're testifying on her behalf.
That's what I said at the time, yes.
Thank you, Ms. Cabrera. No further questions at this time, Your Honor.
Thank you.
No redirect, Your Honor.
Hold on one second. Megan, are you there?
Yes, I am.
Okay. Can you talk to the tab room about bumping the all loss rule?
Sure. Can I find out how much time total is left so I can at least let them know when we should be finished with the round?
Great.
All lost is at 6:25, you said?
Correct.
About 17 minutes left.
And were you asking for how much time each attorney had remaining for closings?
Yes.
Brennan had 8 minutes and 39 seconds, and this is the plaintiff timer. Mr. Norton, I believe, Norman, excuse me, had 12 minutes and 42 seconds left.
Okay, so not much. All right, yes. Let's go ahead and proceed, and I will chat with them, and I'll just, Judge, I will send you a message and let you know.
Okay, just send me a note in the chat.
Yes.
Let's proceed with further examination of this witness.
Your Honor, I have no redirect. Ask that the witness be excused.
Of course. Okay. And I think we're ready for, well, I guess I'll ask, any further evidence on behalf of the defendant?
No, Your Honor, defense rests its case in chief, and we ask that in the interest of all laws, we move directly into closing arguments.
Okay, the rules say that we have to go directly into closings. I think the all loss rule is going to be flexible. I'll put it that way. Why don't we take, Megan, are you there?
Yes, I was just typing it in, but I am also fine with the amount of time they have left. Let's just give them the rest of their time. the tab room's not really going to know until I tell them we're done.
Well,
So
I'm not
I feel like an executive decision is okay at this point, just to save
Okay.
time.
Then I will make an executive decision that you all have the time you have left,
Yeah, and the bailiff supports it. So
regardless of all loss. So you guys, and in part because there are two reasons why. Number one, this is a very good round. And number two, I want to see what you've prepared. I don't want to see a 4-minute closing when you prepared for 6. So let's proceed with the plaintiff.
Yes, Your Honor. The moment Agatha Lee told her granddaughter that she was about to be put back in the will, she signed her own death warrant because of who was right outside that door listening. The defendant heard Agatha Lee say that she was going to take everything from her and give it to her no good granddaughter. The defendant just couldn't let that happen. She had to do something before she lost everything. Agatha Lee had to die, and the defendant was going to kill her. That's why we're here today, members of the jury. It's because the defendant chose to kill Agatha Lee that we filed suit against her. In Midlands, we have something called the Slater statute. What it is very simple. If you kill someone, you do not get the money from their will, and that money instead goes to their next of kin. In this case, Ms. Rogers. We had to prove to you today that Mars, the defendant, knowingly or purposefully killed Agatha Lee. We had to do so by a preponderance of the evidence, which simply means more likely than not. We met that burden today, ladies and gentlemen. We did it by walking you through 3 things because of what the defendant knew, because of what the defendant did, and because of what the defendant left behind. Let's take those one by one. What the defendant knew. See, on August 14th, the defendant knew that Agatha Lee was about to write her granddaughter back into the will. And we know that because of a conversation that we heard about from Stevie Rogers. Now, the defense, they're going to try to come up here and tell you that that's not what happened. That's not true. They said something else. But you need to remember what the defense's own witness, Ryan Cabrera, told you. That just a few hours later, when they were at their lunch date on August 14th, she told Ryan Cabrera she would be meeting with her attorney later that week. She was meeting with her attorney to change the will. That's the evidence that shows us that what Ms. Rogers told us is true. And what the defendant told us is a lie. Now, because the defendant knew that Agatha Lee had to die, that she had to do something before she lost everything, did she know how to kill her? And the evidence shows that she did. She knew Agatha Lee had an allergy to chlorandramine pills. She was the only one that knew that Agatha Lee's chlorandramine pills look identical to her allergy, to her heartburn, to her arthritis medication that she takes, Winterin. And she knew that she could switch those easily. All she had to do was go to a pharmacy, as she did right after this conversation she overheard. Buy them, take them home, and switch them out with no one the wiser. But once she's gotten home, now she actually needs to make the switch. And for the defendant, that's easy. There's not a lock on Agatha Lee's door. She's able to just go and walk on in. But unfortunately for the defendant, she wasn't as sneaky as she thought she was. Someone saw her go. Someone saw her walking to Agatha Lee's room with something in the palm of her hand. Those something were those chlorandramine pills. And we know that it's because of those chlorandramine pills that it's the defendant who committed this crime. Because it was the defendant whose room the chlorandramine pills and that black bag were found in. Now, when you're deliberating, you're going to have a chance to take a look at the photograph that we entered today, the photograph showing where that black bag specifically was found. And you need to keep in mind a couple of things. First, the defendant's fingerprints were found on that bag. She tried to tell you that she'd never seen it before. She didn't know whose it was. That's a lie. Because also the defendant's fingerprint, they weren't found on the side of the bag, or on the bottom of the bag, or the handle, the way you would find something if they were just moving it around out of sight in their closet. Their fingerprints were on the zipper. The defendant's fingerprints were on the zipper within which the chloroandramine was found. She tried to tell you that, no, this must have been planted. I don't know how this could have gotten here. But look at that picture, members of the jury. Look at what it shows. It shows that that bottle of chloroandramine inside that black bag's not hidden in her room. It's set there way out in the open, which leaves you two options. Either it was there the whole time and the defendant says she never saw it. That doesn't make any sense. In her bedroom closet, she goes to every day, looks at every day. She never saw this before. That's a lie. Saying it's planted, she's saying she didn't see that bag put in the middle of her closet at all? No. What happened is that she put the chloroandramine in her bag and she just wasn't able to get rid of it fast enough. She left it behind after she killed Agatha Lee. Now, you need to keep in mind that the judge is going to instruct you that if you find that someone has an interest in this case, if you find that someone lies, you can use that to discount their testimony. And that's what we found about the defendant and not Ms. Rogers, because the defendant admits that she lied at that will reading. The defendant admits that she knew she was going to receive that will and she lied to avoid suspicion of the police. In a few moments, the defense is going to come up here and they're going to try to tell you that actually it was Stevie Rogers who killed Agatha Lee. And when they tell you that, I need you to remember your common sense, your life experiences, because you get to take those with you when you go back to deliberate. And what those will tell you is that that woman you saw, who had lost all of her family, who told you about how heartbroken she was when her parents died, when she told you about the strengthening of her relationship with Agatha Lee, when you got to see her, think about how she is now totally alone in the world. The defense would have you believe she made herself completely alone so she could avoid doing what everyone in the world does every day: get a job. That isn't reasonable. It isn't reasonable because there is only one explanation of the facts that makes sense, and we've proven our burden. The defendant killed Agatha Lee because she had to do something before she lost everything. That's where you come in. Please find her liable. Thank you.
Any response?
Yes, Your Honor. Your Honor, can you see and hear me okay?
Yes. If any juror can't, speak up.
It's a little quiet.
Give me 1 moment, Your Honor. See if I can't turn the volume up a little bit.
No, take your time.
Okay.
And we're gonna rebuff the all loss rule, so you guys have to back me up on this, okay?
Okay, I believe I have my system volume as loud as it goes. Can you hear me okay, members of the jury?
I can hear you. And can anyone not hear him? All right, proceed.
The defendant had to do something before she lost everything. That's what Mr. Bartley just came up here and told you. He tried to tell you that Drew Mars, a woman who had cared for Agatha Lee for the better part of a decade, would suddenly change just like that and murder her. Oh, that Drew Mars would intentionally poison her boss, her friend, someone who she considered family, for money. Members of the jury, what if I were to tell you that Miss Rogers' knowledge of August 14th, 2018, the shoddy investigation carried out by Mr. Bond, and plaintiff counsel's entire case could be explained by one simple principle? They saw what Stevie Rogers wanted them to see. Now, it's not enough for plaintiff counsel to come up here and tell you that the defendant had to do something before she lost everything. They had to prove it to you. But today, plaintiff counsel has elected to sue Ms. Mars under the Slayer statute. This means they had to prove two things to you: that Ms. Mars intended to kill Miss Lee, and that her actions caused her death. And that's not what we heard about today. Today, plaintiff counsel has tried to paint you a picture of someone who was desperate. So desperate that they didn't care about who or what stood in their way. They saw that Miss Lee had money. They wanted it for themselves. But members of the jury, Miss Nguyen and Mr. Bartley, they've been focusing on the wrong person. The real culprit? The person who would do anything and everything to get what they wanted? That was Stevie Rogers. Miss Rogers gains access to a $2 million trust fund in 2008. By 2018, that money was completely gone. So what did she do? She did what she always did when she needed money. She called her grandmother. But Miss Lee had had enough. She wasn't interested in giving Miss Rogers any of that money when she just squandered it over the past 10 years. So she decides to leave everything to Drew Mars. She writes Miss Rogers out of the estate, and she changes her address so Miss Rogers couldn't find her. Miss Rogers doesn't get a job. She doesn't finish those novels she was working on. No, she decides to pay $10,000 and hire a private investigator to find her. Now, that investigator was Mr. Mark Bond. And he finds Miss Lee in just 2 days. And soon after, Miss Rogers shows up on Miss Lee's doorstep. But she wasn't interested in rekindling her relationship with her grandmother. She had her eyes set on one thing, and one thing only: the inheritance that she thought was rightfully hers. And when Miss Lee decides not to put her back in the will, not to make her the heir of that $20 million estate, she got mad. Miss Rogers knew that her grandmother was allergic to chlororantranine. She knew that her grandmother would die if she ingested it. She's the one that put those pills in there. You heard her today. She had multiple opportunities to go in that room and put those pills, and nobody would have known a thing. But what's most important, members of the jury, Miss Rogers knew exactly who to blame it on. Why did she know who to blame it on? Something called the Slayer statute. If Miss Mars is disinherited, Miss Rogers gets the money. She didn't care that her grandmother had to die. She saw what she wanted to see. And she threw her morals by the wayside to get what she wanted. So how did she do it? She switches out those pills and she waits. She waits and waits and waits until Drew Mars bursts into her room and tells her her grandmother isn't breathing. But remember what Miss Rogers did. She calls Mr. Bond. What does she tell him? Not, my grandmother passed away in her sleep. Not, my grandmother needs to go to the hospital. No, members of the jury, she was murdered. How does she know that? Members of the jury, it's because she was the one that did it. She pays Mr. Bond $25,000. Mind you, this is money that she simply doesn't have. And look at what $25,000 bought her. Mr. Bond has no qualifications. He's never been a police officer. He's never had any kind of training to preserve a crime scene. That didn't matter to Miss Rogers. because Mr. Bond was willing to do something that a police officer wouldn't do. Break into somebody's room, open up their computer, take a picture of an email, and not tell a soul about it for 8 days. He never considered Miss Rogers a suspect. He never found it suspicious that she cried murder from the beginning. That's because Mr. Bond saw what Stevie Rogers wanted him to see. No, members of the jury, I get it. This case is a lot to take in. There's a lot of moving parts to this case, a lot of things that look to be one thing, when in actuality, they're completely different. All throughout trial today, Miss Wynn and Mr. Bartley came up here and tried to tell you time and time again the defendant had to do something before she lost everything. And members of the jury, they're almost right. Someone had to do something before they lost everything. Someone was desperate. Someone blew through $2 million in 10 years and wanted more. Someone knew that if Miss Mars was disinherited, Miss Rogers got $20 million. That person made Miss Wynn, Mr. Bartley, the entire MSPD, Mr. Bond, and now she's trying to make you, members of the jury, see what she wants you to see. Members of the jury, I'm asking you to look at what the evidence shows you. Because it only shows you one thing. And that's the truth. And that's why I'm asking you to render the only verdict that the evidence supports and that reason requires. Find Drew Mars not liable for a crime that she didn't commit. Thank you.
Thank you. Further.
Yes, Your Honor, rebuttal.
Go ahead.
Something Mr. Greenwell said just a moment ago stood out to me. There are things in this case that look to be one thing, but in actuality are completely different. And if that doesn't sum up what the defense is trying to do here, I don't know what does. Because what they want you to see, members of the jury, is they want you to see Miss Mars and my client as the same. They had the same access, same knowledge, whatever. They're the same, so you can't figure it out. But they're not the same. There are several key differences between the two of them. Like the first one, the chloroanthramine pills weren't found in Miss Rogers' room. They were found in the defendant's room. The second one, Miss Mars lied about what happened in this case. No one else did. She lied about what she knew about the will. The third thing, Miss Rogers is actually Agatha Lee's family. The last family that she had left was her grandmother, and the defense is trying to tell you that somehow that is less strong of a bond than the bond between an employer and employed. We know that isn't true. There's one more thing that the defendant knew that Miss Rogers simply didn't. The pills that Agatha Lee takes are identical to chloroanthramine. So when she goes in there and switches those pills, Agatha Lee won't be the wiser. Because Miss Rogers didn't know that, she couldn't have been the one to have switched the pills because she couldn't have known it would have worked. But the defendant did. The defendant knew. Find her liable. Thank you.
Okay, the case is submitted. Megan, I am looking to you for what to do.